the purported undertaking made by the claimants while receiving the payment of 2 months' salary in lieu of notice, have inserted on the top of the document that this is for the final settlement of entitlement, which they allegedly stated that title of the document was not supposed to be there, and it was added by the defendant. It also stated that all the amount allegedly paid to the claimants were written by one person. The evidence was written by one person. However, under cross-examination, CW1 has admitted that the document in question, exhibit DWA1 to 11, was submitted by the claimant on the request of the defendant, which will be used to pay them. The witness also has stated that they were asked to submit names, and they have submitted names. The witness further testified under cross-examination that they were paid the amount stated in the document. DW1 in his evidence has stated he is one of the 4 officers that effected the payment as per exhibit DW1A and DW1A1 to 11. With this evidence, can it be said that the claimants have proved beyond reasonable doubt, more particularly when they have proved fraud beyond reasonable doubt, more particularly when the claimants have not tendered a copy of the said document which they submitted to the defendant for the court for purpose of comparison by the court to ascertain the truth about the allegation of fraud or insertion of things that are not in the document, that are not in the original document. I also note that exhibit DWA1 to 11 is a document that has no author and it has no date. The law is tried, and signed and undated document have no evidential value in law. This means exhibit DWA1 and to 111 is a worthless document, a worthless piece of paper, worthy only for dustbin, only worthy for dustbin. See the case of Okapo and others versus Uweke and others, reported in 2007, 10 Nigerian Ukulele Report, part 1043, page 552 at 531. This is notwithstanding that the document has been admitted in evidence. The law is well settled that the fact that a document has been admitted in evidence with or without objection does not necessarily mean that the document has established or made out the evidence contained therein and must be accepted by the court, must be accepted by the court. It is not automatic. It is not automatic. Admissibility of a document is one thing, and weight to be attached to it by the court is another thing. The weight the court will attach to a document will depend on the circumstances of the case as contained or portrayed in the evidence as far as is the evidence. See the case, in the case of Abubakar versus Chuks, reported in 2007, 18 Nigerian Ukulele Report, part 1066, page 368. And that of Bage versus Bage, reported in 1996, the NWLR, part 455. It was made clear that unsigned document has no evidential value. Now, for an admitted document to have any recognition in law, it must have been signed and dated by the maker, where the document emanated from a public institution or a company. It must be signed by any officer authorized to sign such document. The person to sign can be a director, secretary, or any other officer so authorized to sign the document. What the law is after is the identity of the person purporting to sign the document on behalf of the institution or the company or whoever is signing the document. In Anuno B versus Hassan, and another reported in 2013 LPLR 21870, the Court of Appeal Fa Ige held that the law is settled that an unsigned document is a worthless document. A signature by an unknown person or a person not authorized by law when a document cannot cure its invalidity. See Garuba versus Kwara State Investment Company Limited and others reported in 2005, 5 Nigeria Ukulolo Report, Part 9, 17, page 160 at 176. See also Sarai versus Haruna. See also Dante and another versus Kanye. See also Badamasi and another versus Biala and others. All the citations have been supplied. In the circumstances of this case, Exhibit DW1A1 to 11 must be discountenanced and document that was unsigned and undated. See also UBN versus Ishola, ECPO versus State, Omega Bank PLC versus OBC Limited, Infinity Savings and Loans Limited, and Ade Kenya Service Limited versus Ibrahim D. L. Ladan, Esquire, Legal Fidia Citation 2022 to 05, Legal Fidia 77008, Court of Appeal. Having shown that Exhibit DW1A1 to 11 has no evidential value, it is not a document that reliance can be placed on as it lacks probative value. This means that there is no evidence before the court based on which issue of fraud being relied on by the claimant to have respite on the issue of statute of limitation can be properly considered. The claimants have no evidence to prove any fraud by the defendant to enjoy the suspension of the applicability of the limitation law. I therefore found that the claimant has failed woefully to prove any fraud against the defendant. I so hold. I shall now consider whether this suit is statute bar. By the provisions of the limitation law of Cross River State, a claim for debt must be instituted within 5 years unless such debt has been acknowledged or part payment made within the period of limitation, where a statute prescribes a time bar within which an action should be commenced. Such legislation bears the name of limitation law. If an aggrieved person exhibits tardiness by suing his wrongdoer outside the statutory allowed period of limitation, his action is usually declared statute bar. Thus, a cause of action is statute bar when no proceeding can be brought or impose it because the period laid down by the limitation law has expired by affliction of time. See Idigbe versus Ade Parasit, Nasir versus Kano State. See also Container Limited versus Churchgate Nigeria Limited. See Attorney General Adama State versus Attorney General of the Federation. See Mulima versus Usman. See Ibrahim versus Lawal. See NRM and FC versus Johnson. See also Daniel versus Ayala. All the citations have been supplied. It is the aim of limitation law to make a party to be awake, to ginger up aggrieved person to be vigilant, to discourage cruel action, and to prevent the evidence by which a defendant will defend the action. See the case of Arebo versus Ade Kanye. See also Olagunju versus PHCN PLC. See Nasara, see Attorney General, see Nasara Lafia local government versus Nasara State. See also Solgrade Holdings Incorporated versus FGN. See also Asaboro versus Fan Ocean Oil Limited. See also Awolola versus Governor of Ekiti State. See Obazere versus Eko Sueshi. See APC versus Lere. All the citations have been supplied. In determining period of limitation, a court is enjoined to examine the originating process or statement of claim. If the objection is taken in limine, where the limitation period is being determined after conclusion of trial of the entire pleadings, and the evidence adduced will be considered and appraised by the court in order to see when the course of action was disclosed. If the date of filing the matter is beyond the period allocated by the limitation law, then it is statute bar. Conversely, if the time limit comes within the period of limitation law, then it is not statute bar. See Oherem versus Eberua. See also Arebo versus Adekea Supra. See Elabojo versus Daudu. See Williams versus Williams. See Hassan versus Aliu. See Uweke versus Yudizik Oka. See also Saraki versus APC. All citations have been provided. A successful plea of limitation law operate as a shield by an opposing party occasion to ample effect against a claimant action. Firstly, he becomes a destitute of the right of action and judicial relief. That is to say, extinguishes his cause of action. See Egbe versus Ade Prasi Sufra. See Abubakar versus Nasamu. See INEC versus Obadibo local government. See Braibo versus Atande. See Okapo versus BDU, just branch Sufra. Secondly, the court ceases to be crowned with the requisite jurisdiction to entertain his action. See the orders of MB Arabella versus Nike. See also Alagunju versus PHCN. See also Brown. See also JEC Investment Limited versus Brown Line Limited. See also INEC versus Inasito. See also Twain versus Musa. All the citations have been provided. For the purpose of limitation of status, a course of action begins to run when the party becomes aware of an erosion of his right and there exists a person to be sued, the violator, to protect the encroachment right. See Oherem versus Eberua Sufra. See Owi versus Igwe. See UBN versus Ube Diogu. See Okapo Sufra. See Asabo Sufra and a host of other cases cited therein. The gist of the facts of this case as they relate to the issue of statute bar is that the course of action in this case, which borders on arrears of salaries, leave allowances, and medical allowances, accrues to the claimant prior to October 2003, when the claimants were disengaged from services. The unpaid salaries and or arrears of salaries, the unpaid salaries or arrears of salaries, leave allowances, and medical allowances being sought accrued to the claimant before they are discharged from the service of the defendant. However, there is no specific date given. In the circumstances, the course of action will be deemed to have accrued on the 10th of October 2003 when the termination of claimant's employment took effect. This means from 10th of October 2003, 5 years within which claimants were to institute their action before the court will elapse on 9th day of October 2008. However, this suit was initiated at the High Court of Cross River State in 2012. This means the claimant suit was taken to the court 9 years after the accrual of course of action, and the present action was instituted on the 28th day of June 2016. This means this suit was commenced at this court 13 years after the accrual of the course of action. This clearly shows that the claimant's action as it is presently constituted is statute bar. It has been argued that the acknowledgement of the debt by the defendant watered down the limitation law. This submission is based on clear misconception of the provisions of the limitation law. For acknowledgement of part payment to operate as to suspend application of limitation law, the acknowledgement must be made within the period of limitation. From the pleading and evidence before the court, the purported acknowledgement was after the striking out of the suit at the High Court of Cross River State. This means that there is no acknowledgement within the period of limitation. Furthermore, there is also no concrete evidence adduced to prove any acknowledgement of any debt by the defendant within the period of limitation. Rather, even the evidence of the claimant shows that there was no any acknowledgement. Since they said there was no agreement, CW1 clearly in his evidence under cross-examination stated that they never settled the matter. This means even if there is any acknowledgement, it will not account since it was after expiry of the limitation law for bringing the action before the court. And the witness of the defendant has sealed the issue by saying that there has been no settlement. This means that the statute of limitation is not dead. It is still alive as far as this court is concerned, and it operates to deprive the claimant of the right to pursue their claim that is stale. The determination of this issue is enough to dispose of this suit. However, this court being court of first instance, I shall proceed to determine the third issue, which is the claim of the claimant on the merit. This is, if there is an appeal, the Court of Appeal will have the benefit of having the views of this court. Issue 3, whether claimants have proved entitlement to any relief being sought. The law is tried, a claim is circumscribed by the relief claim. Therefore, the claim is required to adduce, the claimant is required to adduce such evidence that will establish the claim before the court. For the claimant to secure a favorable judgment, see the case of Gabriel Atibi versus Camel Metal Nigeria Limited, 2008, LPELR 591 SC. Is reported also in 2008, 10 NWLR, Part 1095, page 399. It is also reported in 2008, 5 to 6 SC, Part 2, page 47, where the Supreme Court has this to say, and I quote, a claim is circumscribed by a relief claim. The duty of a plaintiff, therefore, is to plead only such facts and material as are necessary to sustain the relief and adduce evidence to prove same. He may, at the end of the day, obtain all the relief's claim or less. He never get more, nor does he obtain relief's not claim. A court is therefore bound to grant only relief's claim. It cannot grant relief's not claim. In Summon Up Battling Company, PLC versus Augustus, reported in 2012 LPLR 20873 CA, page 35, paragraph BE, Abba Aji JSC, as she was now JSC, held thus, and I quote, the claims for gratuity, pension, housing fund salary up to 24th day of October 2002 are all special damages and must be strictly proved. That is, each of the said items must be proved to the satisfaction of the court, as the court is not entitled to make its own estimate of same. It must be proved with credible evidence, and without such proof, no special damages can be awarded. See the case of Taylor versus Ogenebo. See also Joseph versus Abubakar. See A.G. Levites versus Aku. See Garba versus Ku. See Osuji versus Isiocha. See Otaru and Sons Limited versus Iris. Citation provided. The respondent has not specifically and strictly proved same as contended, as it is not by the mentioning of the items of special damages as did in the instant case. What about the particularization as to the amount involved as gratuity, pension, housing fund, and salary, etc.? The court is not allowed to make its own estimate of this item. End of quote. See also NLPC versus Kilifo. From the reliefs being sought by the claimant, they are claiming payment of 6 months salary arrears, leave allowances, and medical allowances. This means the claim of the claimant being monetary in nature, bordering on salary and leave and medical allowances are claimed for special damages, which by the above case law have to be especially and specifically pleaded and particularized. Furthermore, in claim for entitlement, the claimant is duty bound to establish his entitlement to what he is claiming and how he came by the quantum of the sum. It is also necessary to point out that proof of entitlement is obtained by reference to an instrument or document that grants it. See the case of Mr. Mohammed Dungus and others versus ENL Consortium Limited, reported in 2015, 60 NLLR Part 208, page 39. Note the oral testimony of claimant, except if corroborated by some other credible evidence. In fact, Mr. Joseph Akonola and others versus La Farges Cement Wafco Nigeria Limited PLC 2015 LPLR 2460630 Court of Appeal specifically cautions against reliance on oral evidence as proof of such entitlement. The claim of the claimant means for special damage must be claimed specifically and proved strictly. The fact that it appears to be admitted does not relieve the party claiming of it of the requirement of proof with compelling evidence. See NNPC versus Kilifo Sufra. See also Mr. Ignatius Ayaw and others versus Mr. Aloysius Uzuaku and others, 2009 LPLR 515 SC. All items of losses must be specified by the claimant before they can be proved and recovery granted by the court. See the case of Christopher Uwaji versus Coastal Services Limited, 2004 LPELR 2106 SC. Furthermore, the claimant has a duty to give specific particulars of the special damages he is claiming. This is to enable the opposing party knows what he is to meet in the case. See Attorney General of Anambra versus CN Odue Sologu Enterprises Limited. And Maritime Management Association Incorporated versus National Maritime Authority. All citations have been provided. I shall apply the above principles on proof of special damages to see if the claimants have by the evidence adduced before the court satisfied the court of the entitlement to grant of the relief being sought. The first relief being sought is for the sum of 4,812,800 naira only, being 6 months salary arrears owed the claimant. The claimant is in attempt to prove entitlement to the relief one, have tendered in evidence at the CWA, CWB, CWC, CWG, CWH, CWI, CWL, CWM, and CWN. From the pleading before the court, the defendant has denied the claim of the claimant and insists that the claimant have agreed to accept payment of 2 months salaries arrears as full and final settlement of the entitlement. What this means is that parties have joined issues on 6 months salary arrears. Therefore, the claimant has the onus first to establish the claim before the burden shifts to the defendant to disprove the claim of the claimant. The above exhibits tendered by the claimant are not capable of establishing the claim of the claimants, the claim of 6 months salary arrears, but the exhibit are not capable of proving the said entitlement of 6 months salary arrears. To start with, exhibit CWC, which the claimant tendered to show computation of their salary and other entitlement to leave and medical allowances, is a document that has no date, and the law is tried. A dated document has no evidential value. Therefore, in the eye of the law, exhibit CWC is not capable of proving claimant's salary. Furthermore, is not capable of proving claimant's salaries, leave, and medical allowances. Furthermore, the defendant has submitted that exhibit CWC is a document that was prepared while this case is still pending before the court. I quite agree with the defendant that exhibit CWC is a document prepared while this suit was pending. Maybe that's why it was not dated. This document lacks evidential value. It is a worthless document that cannot prove what it is meant to prove, i.e. 6 months salaries, leave allowances, and medical allowances entitlement of the claimant. I also note exhibit CWN is a document already before the court which is at variance with exhibit CWC, and it is also undated. This document is affected by the same bias that affected exhibit CWC. It is a document that has no evidential value and cannot assist the claimant in proving any claim before the court. Exhibit CWG and CWH cannot also prove any claim of entitlement to salary, leave, and medical allowances. All that this exhibit can establish is that claimants have made a demand Claimants have made a demand for payment of salary, leave and medical allowances, but not proof of same claim. Furthermore, the member of staff of the dependent who claimed, the members of staff of the claimant who claimed to have lost their letters of entitlement have no any other evidence before the court, to prove the entitlement of their salaries, leave, and medical allowances, as those staff have not appeared to testify in proof of their claim. Exhibit CWB letters of employment. These letters are also not capable of proving salary of the claimant. The reason being that an employee is paid net salary after statutory and other legal deductions. No employee is paid gross salary. For a claimant to prove his salary, he need to tender in evidence either his bank statement of account showing the amount he is being paid, or pay slip showing what is the salary he has been receiving. In the absence of any credible evidence of what the claimant's salaries are, the claimants have willfully failed to prove entitlement to relief 1. Same is hereby refused. The second relief being sought by the claimant is the sum of 7,777,260 naira as arrears of leave grant and medical allowances owed the claimant. As pointed out earlier, the exhibit being relied on in proof of this claim are not capable of establishing the quantum of the claim. The reason being that the exhibit CWC which has the computation of the claimant is a worthless document due to absence of date. The second relief also failed as like the first reliefs, as there is no credible evidence to prove the said entitlement. The third relief is for the sum of 43,433,000. This is claim for damages for breach of contract. The relief 3 is dependent on grant of the first and second reliefs. The claimants have not adduced any evidence to establish the termination of their employment did not follow due process. So the claimants have stated that they were disengaged without being paid any entitlement. This is not enough to prove that they are entitled to any terminal benefit. The evidence from the letter of disengagement clearly shows that exhibit CWM shows clearly that the claimant were given 1 month's notice of termination. However, having been given 1 month's notice for termination, they cannot challenge or be entitled to damages for breach of contract, even if the disengagement is found to be wrongful, which has not been so. The case they can still not be entitled even if the disengagement is found to be wrongful, which has not been found. They would only be entitled. They would only be entitled to 1 month salary in lieu of notice of termination, and not the humongous amount they are claiming. See the case of Ibon Lombe versus Wayek, reported in 1992, 9 Nigeria Weekly Report, part 265, page 303. See Adebayo, Sunday Joseph, and others versus Kwara State Polytechnic, and Gabriel Atibi versus Kabel Metal Sufra. In law, though a party is not obliged to call any number of witnesses in proof of his case, since all he is required to do is to call sufficient evidence capable of establishing the fact as alleged by him, yet where a witness whose evidence would be crucial to settle an issue of fact one way or the other, and thus vital witness, such a witness should be called. And if he is not called, it would be fatal to the case or defense of the party that ought to have called him to testify. In the case at hand, CW1 is not, the evidence of CW1 is not enough to establish the case of the claimant, taking into consideration the diverse nature of their entitlement. It is the law that a litigant need not to call any particular number of witnesses once he has called the number of witnesses which he requires to prove his case, except that failure to call a vital witness would be fatal. See Ali and another versus Ale Siloy. See also Iare Bedel Feeds and Flower Limited. See also Okunade Kolawole versus the state. See also Edeche versus the people of Lagos State. It is therefore my view that evidence of CW1 is not capable of establishing the claims of the claimant, as the claimants having different or diverse claims against the defendant are to testify in proof of their entitlement. Having not testified, the claimants will not be entitled to any claim as they fail to prove their entitlement. In view of all I have been saying above, the claimants have paid woefully to prove any claim being sought before the court. The claimants should lack merit, and same has to be refused, and I so found. However, having earlier found the claim of the claimant to be statute bad, it is hereby dismissed for not having defined the 5 years period allowed by the limitation law, section 16 of the limitation law of Cross River State. I make no order as to cause party to bear their cost. Judgment is entered accordingly.
As the court pleases.
My Lord, we are grateful. Thank you very much.
You are welcome.
Very much.
You are welcome. Yes, registrar, call the next case.
Yes, my lord. Suit number NICS A11 2018 between 1 Mr. Godwin Offem, 2 Mr. Oko, 3 Mr. Emmanuel Ambo, 4 Mr. Martins, 5 Mr. Obama Obete, for themselves and as representing other 25 members of the Summit Limited and Summit Limited. My lord, the parties are not present.
Okay. Appearance? Any appearance? Any appearance? Any appearance for the case of Mr. Godwin Offem? Registrar, are you sure you have served them with the notice?
My lord, the claimant is the same.
You said?
With due respect, is the same.
Yes, you say registrar.
My lord.
The counsel online has muted himself. He should unmute himself.
My lord, that's the claimant's counsel.
Okay. Yes.
With due respect, my lord.
Yes.
For the
Ikoi?
IJOI.
Yes. For the claimant.
For the claimant. Yes.
No appearance for the defendant?
No appearance, my lord.
Have you served them?
Yes, my lord, I did.
This case is for judgment. Judgment will be delivered virtually. Yes, this is the judgment of court. By the general form of complaint dated 9th day of 2018 filed on the same date, the claimant praised the court for one, an order directing the defendant to pay to the claimants a sum of 3,666,460 naira, being terminal benefit. 2, payment of damages in the sum of 5 million naira. 3, cost of litigation 200,000. Upon being served with the originating process commencing the suit, the defendant on the 20th day of March 2018 filed memorandum of appearance. This was followed by a notice of preliminary objection dated 3rd day of June 2019. The notice of preliminary objection was argued on the 29th day of October 2019. Thereafter, the case was adjourned to November 2019 for ruling. The ruling of the court, the ruling on the preliminary objection was delivered on the 19th day of March 2020, where the preliminary objection was dismissed. The defendant decided to abstain from appearing in this matter since the delivery of the ruling dismissing his preliminary objection. It also failed to file defense to the claim of the claimant. The first claimant testified as CW1 in proof of the claim of the claimant. CW1, after identifying his witness statement on oath, adopted same as his evidence in proof of the case of the claimant. The case of the claimant is that they instituted this action for themselves and on behalf of 25 others staff of Earth Summit Nigeria Limited. The claimants asked that they worked for the defendant as security staff until they were laid off on the 6th day of April 2017. The claimants also stated that they were engaged without issues of individual appointment letters and deployed them, and they were deployed to guard the facilities of Shoreline Logistics Nigeria Limited Maritime Road under a security contract between the defendant and Shoreline Logistics. According to the defendant, every month, the defendant sent a security service bill to Shoreline Logistics Nigeria Limited, from which the claimants are paid. The bill is normally accompanied with payment of voucher showing names of the claimant and their entitlement. Exhibit CW1 is a copy of the security service bill for March 2017. It is a case of the claimants that Shoreline Logistics Nigeria Limited has paid the defendant all money spent for the claimants up to the month of March 2017, including the sum of 1,163,622 naira. It is also the case of the claimant that on the 16th day of March 2017, Shoreline Logistics Nigeria Limited gave notice of termination of security service to the defendant with effect from 1st day of April 2017. See Exhibit C3. Following Exhibit C3, the defendant verbally laid off the claimant on 6th day of April 2017 without payment of their March 2017 entitlement. The claimant were stopped at the gate of the Shoreline Logistics Nigeria Limited from entry and were told to leave, and they returned to their homes as they complied. Thereafter, the claimants went to the defendant office in Calabar severally to demand for their entitlement orally, but all to no avail. Due to the refusal of the defendant to pay the claimants their terminal benefit, they wrote letter of demand, but the defendant through its counsel stated that the claimant are not entitled to to their demand. Exhibit C4 and C9 were tendered as proof. The submissions of the claimant, Mr. II Ikoi Esquire, counsel who franked the claimant's final written address, submitted two issues for determination. One, whether claimants have proved their case to be entitled to relief sought. Two, whether by his inability to defend the suit, the defendant has admitted his liability to the claimant. Issue one, whether claimants have proved their case to be entitled to relief sought. Counsel answered the issue is the positive, that the claimant have unassailably proved their case by the required standard of proof in civil cases and thus entitled to the relief claim is their statement of facts. Counsel went on to argue that in civil cases, the burden of proof is preponderance of evidence or balance of probability. It is the submissions of counsel while relying on the case of BB Lodge Limited and Idigbe 2010-41 NSCQLR Part 1, page 1 at page 8 that whoever desire any court to give judgment as to any legal right, liability, dependent on the existence of fact which he asserts was to prove as those facts exist, was to prove that those facts exist. Counsel posited that the claimant's claim is based on pleading contained in their statement of facts, a witness statement on oath filed on 9th day of March 2018. The claim of the claimants is, is that they were entitled to their March salary and 6 days pro rata salary for most of April, having worked for the defendant up to 6th of April 2017. Housing allowance, transport allowance, bill allowance, utility pension, and medical as clearly shown in the computation attached to the security service bill, Exhibit C1, and the computation of entitlement, Exhibit CW12. It is submitted through the claimant that no letter of appointment from the defendant, Exhibit C1 and C12 constitute their contract of service, since it has been sufficiently pleaded that the defendant has been paid them for computation of the entitlement, from computation of the entitlement. To support this submission, counsel relied on the case of Ishebo versus Julius Berger Nigeria Limited, where it was held that a court of law will not find it difficult to grant relief based on labor agreement if the plaintiffs plead it. According to counsel, contract can be established by conduct of parties and not necessarily through express contract. Counsel refers to Section 20 of the Labor Act and submitted that the law admit of implied contract of employment as is the case in this case. It is submitted that having established that there is no contract of employment relationship between the claimants and the defendant is liable to pay the claimant entitlement up to the termination of their employment. The defendant's failure to pay the claimants means that the claimants are entitled to damages for breach of non-payment of their entitlement. It is also submitted by counsel that under Section 8, subsection 1C of Pension Reform Act, it is mandatory contributory pension scheme is set up, which is employee is required to deduct 7% of employees' monetary salary and same percentage contribution from the employer and paid into employees' pension savings account maintained with pension fund administrator. It is submitted that from Exhibit C1, the defendant deducted the contributory savings from the claimant's salaries every month, but Exhibit C7, C8, and C10, the defendant has never paid the contribution of both employer and that of the employee. Counsel Council also submitted by Section 11, subsection 7 of the Pension Reform Act, it is an offense for employer to fail to remit the pension fund and to pension fund administrator under contributory pension scheme. Council asked the court to rely on Exhibit C12 on Exhibit C12 to grant the reliefs being sought. It is submitted the claim for damages is as a result of defendant failure to pay claimants entitlement due to the since April 2017, when the defendant laid off the claimants. Council placed reliance on the case of Alarewajo versus Afri Bank. Council asked the court to grant the claims of the claimants. On issue 2, is whether by his inability to defend the suit, the defendant has admitted liability to the claimant. It is submitted the defendant failure to defend means admission of liability to the claimant. To support this submission, counsel relied on the case of Okoibo versus Police Service Council and others. Counsel submitted that the claimant's witness testified on 14th day of October 2021, which evidence has neither been contradicted nor discredited by the defendant. The law is very clear that a matter like this, counsel also relied on the case of Aike versus Lawal. Counsel also submitted that in this case, the defendant has waived his right to fair hearing by the persistent absence from court, in spite of all the hearing notices ordered by the court and served on the defendant. In support of this contention, counsel relied on the case of Governor of Oyo State and others versus Oba Ololade and Paul Ayan 1995 court's decision. I have earlier in this judgment stated that the defendant being served, despite having been served with the originating court processes, failed to an entry of appearance and filing of preliminary objection, refused to file its defense to the claim of the claimant after the dismissal of the preliminary objection. The law is tried where defendant failed to file defense to appear to defend or participate in the trial, despite giving opportunity to do so, is deemed to have admitted the claim of the claimant. The claimant in this case have argued that they have discharged the burden of proof imposed on them by the law through the evidence of CW1 and documented that and admitted in evidence as exhibit in the course of the trial. This is because the defendant has failed to take advantage of the opportunity afforded it to defend, but failed to do so. Though the defendant has not filed any defense or appeared to cross-examine CW1 on evidence given before the court, the claimant are still by law required to succeed by minimal evidential proof where issues are not joined, as in this case, proof is not required. This right position of the law is what restated is the case of Akibu versus Oduta. However, the claimant's claim as endorsed at paragraph 17 of the statement of facts which have been captured earlier in this judgment clearly shows that the claim for salary, medical allowance, and arrears of deductions of claim for special damages are claims for special damages. See summing up Bottling Company PLC versus Augustus. The fundamental questions that arise is whether a claim for special damages, such as claimant's relief one, in the instant case, will succeed on the disease failure to file defense. The answer to this next question can be found in the decision of the Supreme Court in the case of NNPC versus Kilipo, Nigeria Limited, where it was stated A claim for special damages will not succeed simply because there is admission. There is admission of claim. Special damages are never inferred from the nature of the act complained of. They do not follow the ordinary course as is the case with general damages. They are exceptional and so must be claimed specifically and proved strictly. See Odula versus Haddad. Stressing further on the need to strictly prove special damages, the apex court in the case of Nicn BB Manufacturing Company Limited versus African Continental Bank Limited. The right position of the law, as stated in the above decision of the apex court, is that a claim for special damage, being exceptional and specific in nature, can succeed only upon concrete proof and not admission, either implied or expressed. Put differently, because special damage are exceptional and specific in nature, they will not succeed and will not be granted as a matter of course upon admission, expressed or implied, even where it is specifically pleaded as required by the law. In the case at hand, the evidence of CW1 and exhibit tendered through him cannot by any stretch of imagination prove claim for special damages by law. Special damages is the case at hand. The evidence of CW1 and the exhibit tendered through him cannot by any stretch of imagination prove claim for special damages. By law, entitlement to special damages must not only be specifically pleaded, it must also be strictly proved. Admission either on the basis of default of pleading or of pleading without evidence to show the claimant's entitlement is not enough. To succeed, the success of a claim in special damages depend on the strict proof of what is claimed. Where the claimant fails to prove his claim of special damages, he cannot rely on the defendant's admission of pleadings. And this case is bound to fail. It is to be noted that special damages are not claims that law does not presume or infer from the nature of the act complained of. This is because they do not flow in the ordinary course of events. Like in the case of general damages, they are specially and exceptional in their character. Hence, they must be specially pleaded and strictly proved. Therefore, a party making claim for special damages to succeed in an action for special damages, it must be strictly proved. The term strict proof means no more than that the evidence adduced must ventilate and mitigate the particulars pleaded in the statement of claim. The evidence must indicatively particularize and exactly identify with clarity the above losses with measurable exactitude that the required standard is not especially or exceptionally high to the extent of not being readily attainable. What is required is evidence which is apt and of which a magnitude that lead is set to ascertain proclivity, that is amplified evidence necessary to copiously establish the pleadings and computations about being claimed in any event. What determines strict proof depends largely on the given facts and particular circumstances of each case. Invariably, the burden is in this regard is discharged when there is no credible evidence that enhances proximate assessment of qualification of the alleged losses or damages. It is to be noted that proof in the instant case, the claimant in proof of their claim for March 2017 for salary for March 2017 and pays to 6 April relied on medical allowances for the last quarter of 2017 and arrears of pension deduction not remitted relied on exhibit CW1, CW4, C1, C4, C7, C8, C10, and C12. These exhibits are incapable of proving the claim of the claimants due to lack of evidential value. For exhibit C1, it is a photocopy of letter written by the defendant to Shoreline Logistics Nigeria Limited. This document was tendered in evidence through CW1. CW1 is one of the claimants in this suit. CW1 is not a member of staff before the court to show that the request made by the exhibit CW1 was paid to the defendant. Exhibit CW There is nothing before the court to show that the request made by the exhibit CW1 was paid to the defendant. Exhibit C1 can only establish that a request for payment has been made, but not proof of the payment. I also note that there is also attached to exhibit C1 a copy of the table with column with title payment voucher for As Summit Limited Shoreline for months of March 2017. And there is no officer from the Shoreline Logistics that was called to testify before the court to ventilate the claims of the claimant. Exhibit and for an undated document, except where parole evidence is adduced as to its date, it remains invalid and so has no evidential value. See Arebo versus Chuku. There is no parole evidence before the court indicating the date of any of the undated document in issue. The law is clear that an undated document is a worthless piece of paper. See as Amizu versus Inzeribe. See also Talibua versus Abiba. See Wema Bank and another versus Alaram Frozen Food Nigeria Limited. He worthless, therefore, is document the said document for purpose of this has no evidential value. The claimant did not also help matters by lumping of the various heads of claim as depicted in Relief 1. This clearly shows uncertainty and vagueness of the claim of the claimant. A claim that is vague and lacks certainty is no claim at all. In the instant case, in paragraph 17, subsection 1 of the claimant's statement of facts, the claimant sought an order for lump sum the claimant did not specifically state the sum of the sums for the various benefit being claimed. There is no witness called by the claimant to give evidence as to exhibit CW1 and the purported payment voucher attached to Exhibit CW1 was not signed. Therefore, it is a worthless piece of paper that is, in the eyes of the law, has no evidential or probative value. It is void. See Ojo versus Adejobi. See also SPDC versus Olariwaju. The main relief, which is the terminal benefit, being vague and certain, and lacking in particulars and proof of evidence, must fail. See University of Jos versus Dr. Ike Goha, reported in 2013, 8 Nigerian report part 1360. Indeed, a special damages under our law is capable of being subjected, it's not capable of being subjected to conjecture or speculation or any element of uncertainty. Proof in relation thereto must be adequate and sufficient in order to warrant entitlement, and if it is inadequate, it is entitled the claimant. The law has always been that parties must succeed or fail on the strength of their case as presented before the court. The claimant's claims for special damages in respect of unpaid salaries, medical allowances for first quarter 2017 arrears of pension deduction not entitled. It is a well-established principle of law that social damages claimed by a party must be strictly proved. See Dubes versus Ogboli, 1972, 3 SC 196. See Aguwa versus Oduekwe, 1962, All Nigerian Law Report 557. Whenever special damages are claimed, the party claiming has an appeal tax to strictly prove same. In effect, the rule requires anyone asking for special damages to prove strictly that he suffered such special damages as he claimed. Thus, the claimant should establish entitlement to that type of damages by credible evidence of such character as would suggest that he is indeed entitled to an award under that head. The general law of evidence as to prove by preponderance in civil cases operate in discharging such burden of proof. The claimants fail to prove special damage. The failure to particularize and strictly prove special damage by qualitative and credible evidence renders a claim for special damages credible renders the other two reliefs dependent on the relief or relief one. The future of the relief one means future of the other two reliefs for damages and cost of litigation. The law is well settled that a party to be awarded any relief by a court of law, that party must not only plead with particular but also proved by credible and convincing evidence. A court of law has no jurisdiction to grant party that which he has not asked for and ought not to play the role of Father Christmas. It is pertinent to stress that the claimants failed and were unable to show by the credible evidence to prove the head of each of the items of claim. This is coupled with the fact that the claims are in the species of special damages, which must be specifically pleaded and strictly proved. This was done by the claimant in the instant case, even though the defendant did not file any evidence to counter the claimant's abatement. It is right that admission of special damages does not absolve a claimant from strict proof. Put simply differently, a claim for special damages cannot succeed solely on admission. CNA NPC versus Clip or Supra, where the Supreme Court apply FTA held that special damages are never inferred from nature of the act complained of. See the case of University of Teaching Hospital, Begwinde, and that of Construction Limited versus Isaac. I also note that Exhibit C12 details claimant was prepared by a party interested in anticipation of this suit. Therefore, Exhibit D12, apart from not having evidential value due to lack of date, it ought to have been expunged. For operating section 3. It is right law that document made by a party in a suit or person otherwise interested in the proceeding pending or in anticipation is not admissible and has no evidential value. This affects the mandatory provision of Section 83, subsection 3 of the Evidence Act, which thereby renders Exhibit C12 inadmissible and cannot be acted upon in this case. See the cases of Ladoja versus Ajimobi, CUTC versus Lawal. See also high grade maritime services limited versus FBN. In view of all I have been saying above, the claimants have willfully failed to discharge the onus of proof which rests on them and are therefore not entitled to any judgment in their favor. Their claim being that of special damages need to be particularized. There is no particularization, and the evidence, more particularly Exhibit C12, which is to prove the claim, has been found to be a document that is worthless, that has no evidential value. In the circumstances, the claimant failed to prove their claim. In the final result, and for all the reasons given above, this suit is unmeritorious and is hereby dismissed. I make no order as to cause. Judgment is entered accordingly.
As the court pleases.
We are grateful, my lord.
You are welcome. Yes, Registrar, any other matter?
No, my lord, it was just that too.
Okay, thank you very much, counsel. We have come to the end of today's proceeding. The administrator can discontinue with the meeting. Thank you.